All right, joining us to analyze the recent invasion of Venezuela by the United States forces and the capture of President Nicolas Maduro and his wife, the doctrine of state sovereignty, its limits and broader implications for global peace, security, and international order. As a Professor Agbo Madaki is a professor of international human rights and law, and humanitarian law, rather. Thank you very much, Professor Agbo, for joining us. Now, let us look at the context. Mr. President Bush is being praised to have demonstrated courage and resolve in getting Maduro and the wife arrested. But under international law, what legal grounds, if any, would you say exist for a country like the United States to carry out such military intervention in another sovereign state and arrest its sitting president and even the wife?
Well, it is a very basic and fundamental principle of international law that nation states are sovereign. And these principles of sovereignty is well recognized, especially under the UN Charter of 1945, especially in Article 2, with a lot of emphasis on the sovereignty of nation, independence of nation, and equality of nation. And in any case, the main essence or reason for nations coming together to form the United Nations in San Francisco in 1945, if you look at the preamble of the UN Charter, it says, in order to avoid the scourge of war that has twice plagued humanity, and then with emphasis on human rights, mutual cooperation and development, the UN was established. And all member states of the United Nations, one can simply put it, ratify that treaties. And as such, the Charter is binding on all the members of the UN. And if that be the case, I am at pain to find any legal justification or basis for the U.S. invasion of a sovereign nation and then literally abducting a sitting president. It is a total breach of international law, completely.
Yeah, that same article you said, how does the doctrines, such as responsibility to protect or enforce democracy, how does it weigh against the principle of this non-intervention?
If you look at the entire gamut of the UN Charter, there are limited circumstances that other nations may interfere in the affairs of another nation. And if you look at Article 31, which is a classical example, if the conduct of your neighboring states is capable of destabilizing the peace of the region, but even if that were the case, the United Nations Security Council ought to pass a resolution to that effect before you can intervene. You cannot do it suo motu, no matter how powerful you are. The United Nations Security Council regulates its own affair if you look at the relevant charters of the UN. So for another nation, to go attack the other nation, it must have the backing of the UN Security Council. But the principles of responsibility to protect was actually put together in 2005. And even then, the UN Security Council must give approval before you can attack. And the circumstances and situations on the ground that may warrant an invocation of the principles of responsibility to protect is such a situation that the rights of the citizens of a nation is being abused, there's total breakdown of law and order, and it is necessary to protect and to restore not just democracy, but to protect the fundamental rights of the citizens of that country. But the catchword there is that it has to be approved or by a resolution of the United Nations.
All right, great. It's exactly 35 years ago when Nicaraguan president too was adopted and
Panama.
Yeah, in Panama, the Panamanian president and brought to America for trial on narco-terrorism charges. That's, one of the biggest reasons that Donald Trump has given. And many Western governments, of course, have been known to have questioned the Maduro's administration's legitimacy. But the question again will be, does a context or disputed government reduce the sovereignty protection a state enjoys under international law?
As a matter of fact, the International Criminal Court has had reason to adjudicate and pronounce on similar issues, and that is the case of Democratic Republic of Congo and Belgium. I think it's a 2002 or 2003 case that was determined by the International Criminal Court. In that case, a diplomat from the Democratic Republic of Congo, without his immunity being waived, was arrested and was being prosecuted by Belgium. And then the DRC filed a matter before the International Criminal Court, and the court pronounced and heard that that was illegal and a breach of international law, and heard that his immunity be restored. And then also there's this popular case of Venezuela. What's the name of the case? But it's against the United States. During the Sandinista government in Nicaragua, as the case may be. And then America was backing the Contras. And the International Criminal Court, International Court of Justice, also heard that it was wrong of America to interfere in the internal affair of a sovereign nation. So
I just, cutting you there. I want to ask quickly, in international law, does a state still enjoy or remain sovereign absolutely, regardless of how a government came to power? If you contrast it with what the EU leaders have said about Maduro's reign in Venezuela.
You see, there are two things involved.
Okay.
One is the issue of a democratic constitution, and then the issue of a constitutional democracy. So even if the electoral processes were flawed or is flawed, and a person have been elected according to the constitution of that country and the electoral law of that country, even though the process may be flawed, and it has been heard that there's hardly anywhere in the world that electoral processes have been perfect, but so long as the person has been elected in accordance with extant law of that country, you cannot say that that government lacks legitimacy. It rests with the people of that country to so determine. Look at America itself. The Declaration of American Independence. The Declaration of American Independence, there's a clause in it. It said we hold this as a truth, that all men are created equal and endowed by their creator with certain inalienable rights, among these right to life, religion, ABCDs. And that for this purpose, government is installed among men. And that if any government becomes antithetical of this purpose, there's the right of the people to rise and change it. So what I'm saying is that the only proper means of removing a government that is not performing or antithetical to the larger interests of the people is through periodical elections, and not the use of force. The UN Charter abhors any form of aggression and the use of force.
Okay.
Except as authorized by the Security Council.
Okay. This has not been authorized by the Security Council.
Not at all.
We'll hope
not
probably
at all.
There might still be.
Not at all.
There might still be a chance to
not at
vote
all.
on it. But let's look.
And then let me say something very quickly.
Okay.
In the case of Panama, when Daniel Ortega was picked and tried and jailed in the U.S., the UN General Assembly condemned it. But unfortunately, with the veto power of U.S., the Security Council could not do anything about it.
And we've seen similar, unilateral interventions in places like Panama, just like you mentioned, in 1989, and even in Iraq in 2003. From a legal and geopolitical perspective, how dangerous would you say this latest action in Venezuela in terms of setting a precedent for powerful states to remove leaders they consider or they disagree with or consider not friendly?
No, the truth of the matter is that under international law, group of persons or states are entitled to the right to self-determination, which encompasses a lot of principles of law to determine their own affair. The principle of sovereignty is very, very deep. And no nation, no matter how powerful, without lawful justification, attack another nation. That is aggression. And in any case, if you look at the preamble to the UN Charter, and especially under Article 2, it talks about equality of states. He said no matter how large or small, the nations are equal. So resorting to the use of force, because force may be right or might is powerful as the case may be, we may be returning to the Obesian state where might is right. And then it may lead to a total breakdown of law and order on a global scale, and in turn, jeopardize the peace of the world. And we may return to a scenario that the UN Charter itself seeks to avoid.
But I was just going to ask you that question. This present scenario, does it paint a picture, a situation of the weakness in the United Nations Charter, as a body, other international institutions like the International Court of Justice and even the Organization of American States with this kind of situation?
The UN Charter itself recommends certain method of resolving dispute within states. And it talks about conciliation, pacific approach, and regional bodies intervening. Now, Venezuela and the United States are all members of the Organization of American States, which was formed by way of what we call the part of Samyotse. So many, in fact, that's the Organization of American States is actually the first global regional body, to the best of my knowledge. Yeah. So one of the recommendations of the UN Charter is that if matters cannot be resolved peacefully, if it cannot be resolved through conciliation or mediation, then you go to the regional body. None of these options, to the best of my knowledge, have been explored by the United States. But however, I must point out, what are the reasons has the United States government advanced for this invasion and the forceful abduction of a sitting president? One, they talk of narco-terrorism. They mention that the president and his wife, for the last 20 years in cohorts with the Colombian people, have been involved in drug trafficking to America, and that the natural effect of this is destroying the teeming population of Americans. It's affecting the American economy, and that they have a right to protect their citizens. And that if the UN probably will not do something about it, that America has a right to protect her people by doing what they have done. But I think that America is setting a very, very bad example. Because take it for example, within West Africa, Nigeria is the most powerful country, no doubt about it. In East Africa, it is Kenya. In the whole southern hemisphere of South Africa, as the case may be, it's South Africa. It now means that Nigeria can invade any country in West Africa and remove the sitting president, as the case may be.
Or even Nigeria too can be invaded and removed.
And it also means that Nigeria itself may be invaded one day.
Okay. Finally, let me ask you this question. Now that President Maduro and the wife are in the custody of the United States government, what kind of legal protection would they enjoy as individuals? Would it be under international humanitarian and human rights law? And who would we say would exercise that jurisdiction? The U.S. courts or international tribunal?
No. You see, America made it very clear that the Venezuelan president will face criminal trial in accordance with American law. And I must point out very quickly, now, just like in the past in Nigeria, and this is a common say among lawyers, that how you obtain evidence is not important, but the relevance of the evidence and the way that the court will attack to it. So there's also a legal principle in America that how you bring a person to face justice does not matter, so long as excessive force was not used. So the fact that he has been picked up from his own country and brought to America has nothing to do whether he's properly before the court. He will be tried in accordance with American law. But however, under international law, any person facing trial is entitled to his rights being respected. And America is a signatory to the International Covenant on Civil and Political Rights that guarantees citizens of the world all the basic fundamental rights, as the case may be, that guarantees. So, notwithstanding the gravity of offense that they may have committed or deemed to have committed,
alleged
to have committed, I believe he will still be entitled to a counsel, and all the due processes of law that America is known for. Now, even without having been asked, what are the lessons for the rest of the world to learn from this matter? One, that electoral processes must be free and transparent and allow the vote to count and allow the voice of the people to prevail. Because one of the grievances against Maduro is the fact that he did not win that election. Then number two, there must be respect and observance of the rule of law. Sitting presidents all over the world, especially in Africa, must abide by the Constitution and the rule of law and rule their people with the fear of God, knowing that power is transient and knowing that they are nothing but mere custodian of this power on behalf of the people that have donated the power to them.
Thank you so very much, Professor Agbo Madaki. No better place to drop the anchor on our chat on the forceful arrest of the Venezuelan president Maduro and his wife to the U.S., who will be standing trial in the court in New York. Professor Agbo Madaki is a professor of international law. Thanks for coming on.
Thank you very much.